And Mr. Williams, the record will also reflect that we are all in court for the sentencing proceeding, but you had requested that you be able to participate by video telephone conference. Is that correct?
That's correct.
And you are consenting to participating in the proceeding by video teleconference. Is that correct?
That's correct.
And the court makes specific findings that pursuant to Section 15002 of the CARES Act, that this proceeding, that is the sentencing hearing for Mr. Williams, must proceed by video telephone conference, that Mr. Williams is confined at the Federal Detention Honolulu, and if he is brought into court, then he'd have to undergo 2 weeks of quarantine. In addition, the current coronavirus pandemic makes it a threat to health and safety for him to participate in person. And in light of the Chief Judge of the District of Hawaii general order extending time for hearings to be held for sentencing and change of pleas based on the CARES Act. Also, his general order extending the time where we will not be having any jury trials until November 15, 2020. And in light of Governor Ige's recent general order not permitting inter-island and mainland travel without a 14-day quarantine unless people meet the testing exception. The court finds that Mr. Williams has consented to proceed with the sentencing hearing, and the court finds that it is necessary to hold this hearing by video teleconference for Mr. Williams. Are there any additional findings on Mr. Yates that you believe the court should make on the record?
No, Your Honor.
Thank you. All right. You may all be seated. So, Mr. Williams, we're here for your sentencing hearing. I'm going to make certain findings at the hearing, and then I'm going to go through what I believe to be the aggravating and mitigating factors in your case. I'm then going to give the opportunity to the attorneys for the government to put their position on the record, what they believe is an appropriate sentence for you. And they also have the opportunity under the law to present any victim witness testimony. Then I'll turn to you and give you an opportunity, as you're representing yourself, as well as you being a defendant, an opportunity to state your position. And then I'll take all of this information and craft the sentence that is sufficient but not greater than necessary to meet the goals of sentencing, which under the law are just punishment for the offenses to which you've been found guilty by the jury, to hopefully deter you and others from similar types of conduct in the future, and to give you an opportunity for rehabilitation. So to that end, let me confirm with you and Mr. Isaacson that you both have had a full and fair opportunity to read, review, and discuss the pre-sentence investigation report and the addendum, and to file any legal or factual objections to that report. Have you had this opportunity, Mr. Williams?
To the initial report I have.
Correct. The draft pre-sentence investigation and report. Did you see the final version of the report?
Yes, we saw the final version.
All right, very good. Mr. Isaacson, would you agree with that?
Mr. Williams and I have had discussions of the PSR, and have had a chance to file objections, because we had none.
All right, thank you. So the court has reviewed the pre-sentence investigation report and the addendum, the government sentencing statement, the defendant's motion for variance and sentencing memorandum, the defendant's sentencing statement that was filed September 21, 2020, defendant's submission of support letters, defendant's second submission of support letters, and defendant's third submission of support letters. So that's what the court reviewed for this. So the court makes the following findings. Then on March 3, 2020, Mr. Williams was found guilty by jury verdict as to counts 1 through 32 of the superseding indictment, charging him with counts 1 through 15 of wire fraud and counts 16 through 32 of mail fraud. I now place the pre-sentence report in the record under seal. If an appeal is taken, counsel will have access to all of the report. There are co-defendants in this case, and they include Mrs. Williams, Ms. Bebe, and Mr. Molyneux. Yeah. I have received and reviewed letters of support that I have just described. It's my understanding that the government filed objections to the factual findings and none to the application of the guidelines to the facts. Are there any remaining objections that the court needs to address at this time, Mr. Yates?
No, but I'd like to, one thing clear, the court has just described Henry Molyneux as a co-defendant. He's not technically a co-defendant in 17101. He is a defendant in a separately charged matter. The other thing I note, the government did file a late sentencing response to a motion for variance. It's a simple one-issue matter, and that only becomes relevant to the extent that there is some dispute over the application of an adjustment. Otherwise, what Your Honor has said is correct. We have nothing further to add.
All right, thank you for that clarification. All right, so Mr. Williams, you have filed a number of objections to the draft pre-sentence report, and as a result, an addendum was prepared to the report, and based on the responses by probation, do you have any remaining objections that you want the court to resolve?
All my objections are on the record.
All right, thank you. So the court notes that in the addendum to the report, pretrial has set forth each of the defendant's objections and has provided a response to each of these objections. They are numerous, so I'm not going to go over them individually as they were. There were only 5 or 10 of them. But these do appear in the final sentence, 55 through and including 69. The court has reviewed each of your objections and probation's responses. In some of the cases, there have been changes made. For instance, you submitted your true name, and that was the face sheet was amended. But for the majority of them, the response by probation was that it stood by its analysis and it provided a explanation. And so for the record, the court agrees with all of the responses provided by probation and is prepared to adopt the factual findings in this report and overrule those objections by Mr. Williams where probation has not agreed with his objections. I reviewed Mr. Williams' motion for variance and sentencing memorandum. I interpret the sentencing memorandum to be a request to consider specific 3553A factors, and I have done so. The court determines that the applicable guidelines are, which is the largest total offense level 41, total offense level 41, criminal history category 5. This gives a guideline range for counts 1 through and including 32 of 360 to 7,680 months. Supervised release and each count 1 through 32, 1 to 3 years. Fine for cost of imprisonment and supervised release for counts 1 through 32 each, $50,000 to $250,000. Restitution in the total amount of $230,527.13, and a mandatory special assessment of $100 per count, for a total of $3,200. So these are the factors the court sees in aggravation and in mitigation. In aggravation, turning first to the nature and circumstances of the offenses, your offenses involve taking advantage of homeowners with the promise of helping them with debt relief on their mortgages. Instead, you diverted these payments to yourself and others, and many of your victims were foreclosed upon, or had to declare bankruptcy, or were evicted from their homes, or suffered other damage, such as to their credit reading. Some of your victims you'll be given an opportunity to speak, Mr. Williams. This is the court's time to go through the factors it sees. Some of your victims were paying for mortgages that housed extended families, so when they were evicted or foreclosed upon, several families, not just one, were made homeless at that time. In addition, your role in the offense, you were clearly the leader and organizer. You came up with a format, a document, and sort of the sales pitch with regard to this scheme. You falsely represented that you had official federal authority and that you were a lawyer or had some sort of legal expertise or training in the law and in mortgage lending. Many of your victims were particularly vulnerable because they did not speak English as their first language and were recent immigrants to America. You and others, such as Ms. Cabede and Mr. Malane, actively recruited members of the Filipino community here in Honolulu and on the New Islands and convinced them that you had official authority. At your direction, various ineffective but official-looking documents were filed with the court and the Bureau of Conveyance. For as a result, your victims were billed monthly and made payments to you and other entities that you had established, which is MEI, rather than pay their mortgages. Tuesday, Wednesday, Thursday. You created false and fraudulent documents that purported to be notarized and filed them with the Bureau of Conveyance, thereby undermining our legal system and falsely representing to clients that their prior mortgages were discharged. The overall actual pecuniary loss totals $230,527.15. The actual and loss and restitution owed each victim was set forth in pre-sentence report attachment A. Relevant related conduct includes in aggravation. In addition to actual loss, there is intended loss because you had your victims execute mortgage notes as well as have your entity MEI send checks which will return to insufficient funds. And MEI cashed some of the checks from the victims. This intended loss is calculating the pre-sentence report is over $1 million, $1,570,489.91. Other aggravating factors include personal characteristics, such as your past criminal history. About the same period that you were engaging in these offenses in Hawaii, you were convicted in other jurisdictions for driving without a valid license. This is significant, even though it's a traffic offense, because you attempted to use false credentials as a private attorney general, and you were convicted of practicing law without a license. This is the same type of false representation that you made to the victims in Hawaii. Most significantly, you were convicted in 2017 for grand theft, and the fact of that conviction also involved you and your entity, MEI, filing fraudulent mortgage and financing documents in Florida. For that offense and conviction, you're currently serving a 15-year sentence of incarceration. The court finds that these factors are in aggravation and so that you can be resent your risk of recidivism and harm to our community. There are certain factors in mitigation. You are a high school graduate. You served in our armed forces and was honorably discharged. You have the support of family members and friends who have filed letters in your support. Your crimes in this case of which you've been convicted do not involve crimes of violence or drug distribution. We have no recent history of drug addiction or drug abuse, and we have no history of mental illness. These factors in mitigation show that with supervision and assistance that you can be rehabilitated and can come back into our community and hopefully be a positive force. So those are the factors the court sees both in aggravation and mitigation in this case. I'm going to turn now to Mr. Yates and give him an opportunity to state the government's position as to what's an appropriate sentence and to provide any testimony if he intends to of any of victims in this case. And then Mr. Williams, I'll turn to you. Mr. Yates.
Your Honor, I was instructed to stand to the podium.
Yes, please. And I think then Mr. Williams can see you. And Mr. Williams, if any time you cannot hear us, please let us know.
Thank you, Your Honor. If I may proceed. The government concurs with the TSR and the probation office's recommendation. We acknowledge that it is a very steep recommendation, a very tough sentence of 360 months total. But we offer that this is particularly egregious conduct, and although it was a fraud that involved relatively small amounts of money, it was against a particularly vulnerable population, as the court has acknowledged, and for whom a little loss drove people a long way down. As the court has acknowledged, and certainly as the probation office has recognized, the defendant diverted mortgage payments from the banks, from the victims, and as a result, they left the victims at risk for not just the loss of a few $1,000s, but rather complete and utter financial ruin. The government called representative witnesses to testify for the federal jury, and the court has heard testimony that there were victims who went into bankruptcy, who were foreclosed upon, and some, as the court has acknowledged, that were driven to homelessness. We needn't go through with that testimony again here. We made the decision not to call these witnesses to relive their experiences because these witnesses did testify in open court, and Your Honor was present to hear that testimony. And there's no need to go through it again. But we will acknowledge and we will note certain other factors that were not mentioned, and we think that it's important that not only was this a vulnerable population, but they were vulnerable in particular to the representations that the defendant was making. The defendant passed himself off as an FBI agent or as a federal agent. That was the testimony from Mary Jane LaForteza and from Julita Ascension. The defendant claimed over and over again on the stand that he never represented, he was a lawyer, and yet he presented video in which he clearly recognizes himself as a lawyer. And it was in relying upon those representations that these victims came to sign up for the MEI program. They trusted Mr. Williams, and 112 of them that we found suffered as a result to varying degrees. Now, other things we'd like to note that are not expressly referenced in the probation officer's report, but which are important, is the defendant's callous disregard to the harm that he caused others. We needn't press too far on the issue of the victim clients, but there were other victims here other than those who paid money to Mr. Williams. There were, in a manner of speaking, his co-defendants and other third parties that he recruited into his scheme. Among them, Mr. Henry Molyneux and Annabelle Kabebe. These are people who certainly were complicit and certainly deserve to, but they were themselves also victims. And they were also people who relied upon Mr. Anthony Williams and his representations to their detriment, because not only did they lose their houses, but they are now facing criminal liability for their conduct. I'm going to note also the example of Ms. Barbara Williams, a woman in her 70s, a woman in poor health. Mr. Williams thought nothing of including his own mother in this scheme and subjecting his own mother to criminal liability. Mr. Williams turned honest people into his defenders. Some of the victims straps to believe a lie that helps him. But even these are not the only victims of the defendant's scheme, because there were certain institutional victims. The banks, for instance. The defendant's scheme involved convincing all of his clients to simply stop paying other mortgages. Now, the government has counted 112 people whom he convinced not to pay on their mortgages. That's a significant disruption in the operation of these banking institutions, and those are just the ones who paid MEI directly via checks. There were others who paid Mr. Williams or his agents in cash that are not counted in that number. But that is a substantial disruption in the operation of the banking institutions that could have, had it continued, resulted in significant bank losses, if not closures, of businesses here in Hawaii. There's also the issue of the courts. The defendant's scheme involved attempting to stop these banks from seeking redress against those who were no longer paying them. And he did so by flooding the courts with frivolous filings involving bogus documents. Now, this has happened in numerous foreclosure actions, as Mr. Williams testified to himself, and as he elicited testimony at trial. But it also, frankly, happened in this court has borne witness to the kind of frivolous filings that Mr. Williams was capable of. And by clogging the courts, he was denying justice, not just to the financial institutions that were not receiving their mortgage payments, but also to the public as a whole, who was being denied access to the courts. So these are all significant, and they weren't discussed in the probation office's PSR. Other matters we point out, there is no acknowledgement for the harm suffered by the victims, either by the victims, the homeowner victims, or the institutional victims. There isn't that kind of acceptance of responsibility. Now, we understand the defendant here intends to appeal his matter, and he has that right. But we do believe that's an important thing to point out. Now, I will leave it to the defendant to talk about the matters of mitigation. They were outlined by the court, and I'm sure that the defendant will have much to say in that regard. But I will point out for the court's attention the matter of the defendant's letters of support. It is true that the defendant did submit letters of support, but we note that with the possible exception of a few letters from his family, those letters of support are either inapposite entirely because they address his pretrial detention, or I should say pre-sentencing detention in light of the COVID pandemic, or they seek to express the defendant's innocence, that the defendant deserves no prison time at all. Now, typically, when the court receives letters of support, these letters reveal something about the defendant. They show and they corroborate the defendant's good character, honesty, diligence, contrition. The letters of support that were signed and sent to this court, aside from those from the defendant's immediate family, appear to show quite the opposite. That the defendant has continued his fraud and continued to convince those around him that he did not engage in the kind of activity that a federal court and, the federal jury convicted him of. So for these reasons, Your Honor, the government does concur with the probation officer's recommendation, although it is a very substantial sentence. We did struggle and we did consider strongly the issue of concurrent versus consecutive sentences. We concur with the probation officer's recommendation with respect to grouping the counts 1 through 31 and then running consecutively count 32. On the other question, the concurrency of the state sentence, this was a matter that we did wrestle with as well. There are many reasons to run this sentence consecutively to the state sentence. The defendant was convicted, as the court is aware, in connection with the theft of a single property in Florida. Now, that involved a different victim.
Are you consecutive or concurrent? Is the recommendation concurrent?
Correct. Correct, Your Honor. I'm getting to that.
Oh, okay. I just wanted to make sure. run.
No, I apologize.
Thank you. No. I just want to make sure. Okay, thank you.
So it was certainly it was certainly a decision we wrestled with, and there are reasons to run this consecutively. However, we do acknowledge that this ultimately was the same scheme, and that we do acknowledge that it was the same modus operandi that was utilized in Florida and in Hawaii. So with that in mind, we do concur also with the probation officer's recommendation that this sentence run concurrently with the Florida sentence.
Okay, so that I understand, you're saying that when you struggle with whether you should recommend consecutive or concurrent with the board of conviction because of the similarity of the type of offense.
Correct.
You feel that it's appropriate to run it concurrent.
Correct.
For instance, if it was a crime of violence in Florida and then it was this fraud crime, those would be so different that you would make an argument that potentially consecutive would be more appropriate.
Certainly, and more to that point, not only in the situation of violence, but in here, what makes this a close case is, the government made a special effort to make sure that we're focusing on Hawaii victims in the presentation of this case here, because what made this scheme in Hawaii so egregious, and what distinguishes it from the situation in Florida, is that the defendant sought out particularly vulnerable populations, and it was only in a place like this, in a community that was as susceptible, could his scheme have found such purpose. It succeeded as widely as it did because he found a uniquely vulnerable population. Those circumstances did not exist in Florida.
Okay, so I've struggled with this also, and I'm sort of inclined to land at a different place, which is consecutive. For that reason is that when you commit the same kind of crime and you go to another place, and you use the same scheme, and then you target this vulnerable. At that point, he was sort of on notice that these things, even though he didn't agree with it, for his testimony at trial, he had certain beliefs about the processes and so forth. You're at least put on notice by law enforcement and the court that others see it differently, and you're actually charged, with that kind of criminal conduct.
Yes,
You're kind of put on notice at that point, so that's why I was leaning more towards consecutive. But I hear what your argument is. I mean, some of the, like the prison cases that we've had where they're in prison for a totally different offense, and then they commit something while they're in prison, the argument is to run it consecutive because they're very different crimes. Okay, so I understand what your position is.
It was a close call for us, Your Honor, but I think I've said enough on that subject. I've nothing to
Thank you. Did you want to present any other evidence or testimony?
There's nothing further that we require, Your Honor, because of the 4-week trial, and we believe that the evidence was appropriately summarized in the probation officer's case.
Yes.
Thank you.
I think she did a phenomenal job. It was a 4-week trial, and there was a lot of evidence and documents, so certainly commended. All right, so Mr. Williams, now you have an opportunity to speak on your behalf and point out what you believe to be the appropriate sentence for you.
First of all, I want to say everything that liar, pedophile, persecutor, Jake Paris Yates says was a blatant lie. That's the number one.
All right, first of all, you have a right to speak on your behalf, but I'm not going to let you call other people names with regard to that. So if you do it again, then I'm going to cut off your ability to have Mr. Isaacson do it in your stead. All right? It has no place in your position with regard to sentencing. So you're on warning. All right. So what's your position?
Well, the position is I shouldn't get no jail time, first of all, because I didn't commit a crime. The people that committed this crime, I'm the one that actually went to the FBI, filed a complaint, not only with the FBI, but with the DCCA. I sent the email, I sent the fax letter, and I showed up in person to personally make a complaint about what these people did with my documents and scamming people under my good name and my good company name and my good company's reputation. I sent my process to the FBI office in every state that I was in. Now, he's going to sit up there and lie and say I chose some vulnerable victims when I was sought out by these people. They're the ones that called me to Hawaii. I didn't know nobody here. They're the ones that called me here because they saw the work that I did in the other states, such as Florida, which the Florida FBI put me under the same bogus investigation that this FBI did, but declined prosecution because they couldn't find any evidence of no crime because there was none. Because I was proactive before I set up my company up. I sent all my processes and documents to the FBI for them to scrutinize. If anything in it was fraudulent or could be deemed as fraudulent, to please notify me before I even set up my company. So there was nothing that I did that was fraudulent or intended to be fraudulent or that was fraudulent against any homeowner in any state, let alone here in Hawaii. I never represented myself as an attorney at law. My website that you all prevented from coming into the evidence shows specifically that I do not want to be an attorney at law. Neither am I a member of the Bar Association, neither do I claim to be a member of the Bar Association. I am a private attorney general or an attorney in fact. And the reason why I can't claim that I was an attorney or attorney in fact for my clients, because every client filed a power of attorney, which is according to your own Hawaii Revised Statute 55-1D and also the Tennessee Code Annotated 34-6-109 to 111. And this is how I was able to represent and assist all my clients in courts in all the states that I have an office set up. Also, under the federal law, Rule 17, under Next Friend, I was able to assist clients here in Hawaii and other states, which they on video with me assisting clients here with no problem with several of the federal judges and state judges in these courts here. None of the documents that I filed were false or fraudulent. I've never been charged with false documents in Hawaii, filing false documents, because I had all my documents approved by the district attorneys in the counties I was in, the anti-predatory lending database, and also the FBI, that nothing I was filing was fraudulent or could be construed as fraudulent. The witnesses that they were able to coerce at the trial by lying, the Madambas gave me a affidavit stating that I was not the one that scammed them, but it was Henry Malinay, Annabelle Baby, and Rowena Valdez. Those are the people that scammed them, but 5 years later, they were coerced by the prosecutors to be able to lie on the stand that I lied to them about what their process was. And it's very upsetting and disturbing that these prosecutors would cherry pick the MBI application and only mention the homeowner's guarantee service or the homeowner service guarantee, but fail to mention the foreclosure disclosure that every client had to file and had to sign, which specifically stated that if they were facing foreclosure, that they did not qualify for the mortgage reduction program. And that's what all the clients here understood, that I would be fighting in their foreclosure and helping to assist them to stay in their homes, which I did, which is reflected on the record with the plethora of motions that I filed, that most of my clients are still in their homes. Of the 112 people, probably 3 or 4 people are not in their homes. And they're not in their homes not because of me. It's because I was unlawfully incarcerated for 9 months where I could not litigate on their behalf on things that was not my fault that I was incarcerated wrongfully. I won my case and came back to assist these same people. I did not represent myself as an FBI agent. The government witness, Melvin Ventura and Mary Jean Castillo, both testified, especially Mary Jean. She was in those conferences with a lot of those clients that were signed up, that actually even was testifying to prove that I did not make those misrepresentations. Those people blatantly lied on the stand. I showed the documents where they lied. Lorraine's proxy stated that I didn't do anything for her. I showed by the exhibits how many motions I filed on her behalf. I had to take over her litigation, which she had went to Edna Franco, and I had to step in to take over that litigation to keep her in her home, which she still is. I did not cause any harm to any client, and that's the reason why I did not have any complaints filed against me from that day to this one. Still, even the people that came to court to testify still never filed a complaint against me because I did what I was supposed to do. The FBI agent, Megan Crowley, took it upon herself to go to my client's homes unannounced, uncalled, and did a 302 report. In all of her 302s, not one client stated that I scammed them or defrauded them. Those 302s were not let to come in to the evidence where the jury could have saw her own words that these people that she interviewed stated I did not do anything wrong to them, but I did everything that they paid me for and also still worked for them when they couldn't pay me. Henry, now he tried to allude to the notion that Henry Malinay and Annabelle Kababy were victims of mine. These people were liars. They were scam artists. I put them on my website because of them scamming people and conning people, and they also conned me. More specifically, Annabelle, because Annabelle's the one that told me that Henry Malinay and Edna Franco had opened up a bank account, but she didn't tell me that she was one of the signers on it. So I defended this woman all these months against the DCCA, thinking that she was an innocent bystander when she was one of the main culprits in the fraud and setting up the mortgage enterprise to try to make it look like it was mortgage enterprise investments. Then they try to allude to the fact that I tried to make my mother into a victim. And the reason why my mother even was involved is because the FBI went around to all the banks here in Hawaii and made me close my banks. They closed all my bank accounts that I had set up here in Hawaii for my clients here, and I had to set up an account in Texas so my clients can have somewhere to send their payments to, because I wanted to make sure that there was a paper trail for everything that I did. This is not the modus operandi of a scam artist. Scam artists do what Henry Malinay and Edna Franco and Annabelle Kababy did. Take money from people, cash money, with no receipt and no paper trail and no work and no services rendered. That's what they did. I videotaped me going into court defending these people. I videotaped me going to the FBI making a complaint against these people for the fraud they committed against me, my company, and my clients here in Hawaii. You all heard testimony from clients that knew these people. Miss Rosie Thomas, Miss Elavila Giles, Miss Mila Castro. These are Filipino Hawaiian people. And they're talking about I targeted vulnerable Filipinos. Filipino people were not the only people that I had as clients. I had Caucasian clients. I had Samoan clients. I had Hawaiian clients. I had African-American clients. I had Hispanic clients. None of them were vulnerable. The Filipino clients, that most of my clients were college educated. They weren't ignorant people. They weren't scammed. They weren't duped into signing up with my program. They was explained to, the program was explained to them fully and sufficiently, and I took my time to go that. It's not complicated. It's not a whole lot of legal jargon, so no one was scammed or no one was duped into signing that application and signing up for my services. Before anybody signed up for my services, I always encourage them to do research on me to make sure they understood who I was, what I am, that I'm not a member of the Bar Association. Neither do I ever want to be a part of a corrupt association like the Bar Association, where it's okay to lie in order to get a desired result. I cannot do that. I represent my people with integrity and honesty, and I always would do that.
So, Mr. Williams, you've been speaking for about 10 minutes, and I'm happy to hear your argument with regard to an appropriate sentence. You are really rehashing the trial which has been held, and after the deliberation, the jury has found you guilty of 32 counts. So it's not helpful to the court if you want to argue with regard to the sentence, the reasons why an appropriate sentence would be less than what Mr. Yates has argued for. I'm happy to hear it. Otherwise, rehashing the evidence presented at trial is more appropriate on appeal. So I'll give you 3 more minutes if you want to bring up any points with regard to your sentence.
Well, first of all, the sentence is ridiculous. A 30-year sentence, a sentence that is far beyond a sentence that a murderer would get, a rapist would get, or anyone that actually had victims. This sentence that they're proposing is, quite frankly, racist, it's discriminatory, and it shows the disposition of this prosecution that they didn't charge not one Caucasian employee of mine here in Hawaii or any other, but they only charged me. And now they want me to serve 30 years for assisting people into staying in their homes, and they know good and well that the people that did lose their homes, it wasn't because of something that I did. It was because the banks foreclosed on them illegally and unlawfully without a trial by jury, and I did everything that I could to keep those people in their homes, and the ones that did get foreclosed on was because I was incarcerated. Miss Thomas and other ones that was able to keep in contact with me are still in their homes because of what I did. So they're proposing a 360-month sentence or 30-year sentence when Henry Malinay and Annabelle Kabebe haven't done a day in prison and are not going to do a day in prison because of the way that they got a plea deal and then was taken off my case as a co-defendant so they would be subjected to these inordinate and ridiculous sentences for mail and wire fraud. Also, under the mail and wire fraud statute in the United States Code, under a Class C felony, the maximum you can get for a Class C felony is 12 years. And now they have 30 years on a wire fraud and mail fraud, which there was no fraud that they ever showed in any of the emails or the 16 payments that were sent. 16 payments that were sent, 12 by Mr. Ventura and 4 by Mr. Evelyn and Arnold Subia. And Mr. Ventura gave me several affidavits, and he testified on the stand that he still trusts me and still believes that I'm a man of faith and I'm a good man. Because all the testimony that he said, the prosecutor did say that the other letters of support said that I didn't have integrity, that's a lie. The letters of support, if you read the letters from Dr. Horwitz, Sherry Kane, Ms. Robin Krakauer, Renee Powell, all of these are Caucasian people that know me, that I assisted in their fight against foreclosure. These people are not ignorant of the law. I made sure that they researched. Everything that I did was honorable. That's the reason why I was transparent with my company. So a sentence of any days in prison is a travesty of justice. It's a miscarriage of justice. I've already done time illegally and unlawfully for a crime that I did commit in Florida. He brought up the Florida case. I was not convicted of Florida with the same conduct. This is what they're alleging. No, I was convicted in Florida based on them saying that I filed documents to steal a house from Bank of America. There were no homeowner victims in the Florida case, just like there was no victims here. But they try to make it like it was the same foreclosure scheme in Florida, and it was. The same foreclosure scheme that they're claiming that I did, the FBI in Miami investigated me and declined prosecution. And the reason why they prosecuted me here, because they knew they could get an all-white or all-Asian jury that they could not get in Florida, because no self-respecting, law-abiding citizen could have sat on that jury and convicted me unless it was an all-Caucasian and an all-Asian jury. And so I do not deserve any sentence because I did not commit no crime, and I still maintain my innocence. And I got witnesses that will testify today to that fact.
All right, thank you very much.
Whenever it's appropriate, Your Honor, I've been notified that there have been victims who desire some time to address the court.
Oh, okay, so you do want to present. All right. All right, so I think this would be an appropriate time before I determine the sentence. If you could come up to the podium. Good morning. You could state your name and speak into the microphone so that we all and the reporter can hear you.
Okay, I'm pretty nervous. Before I begin my testimony, I would like to acknowledge and give glory and honor unto Yahweh Elohim Yeshua.
Could you state your name today? I'm sorry. Could you tell us your name first?
Yes, I am getting to that. My name is Rosie Esprecion Thomas, and I'm here as testimony to support Anthony Williams. Thank you, Your Honor, for allowing me to give this testimony today. I respect you and I give you my thanks. To Anthony, thank you for trusting me. I respect you. I love you as my brother in Yeshua. Mr. Isaacson, thank you, and I respect you for what you're doing for Anthony. To the prosecutors, Mr. Sorensen, Mr. Yates, FBI investigator, Ms. Crawley, thank you, and I respect you as well. And to all who are here today in the courtroom, and for all those who are listening in outside of this courtroom, aloha to all of you, and I give you all my love and respect to each one of you. Before I begin my testimony, I felt it is necessary to state my credentials, not to brag, but rather it is my humble intention to affirm to this court that my intent is for all of you to quote unquote to connect the dots and to validate my testimony as chronologically as I could to ensure and assure this court that my testimony are factual and are the truth, as I am monitored by Yahweh Elohim Yeshua, as it is Him always that I answer to. 1981 to 2012, I worked full-time as a registered nurse in 3 major hospitals here in Oahu. My passion of the nursing career was working in the intensive care unit. 2006 to 2012, while working full-time as an RN, I slowly started my CMA, Case Management Agency, as an entrepreneur, as my second job. My CMA's function was to manage the foster care home operators in Oahu and also to manage the care of elderly, who are our local pupunas who required placement in a foster care home as they required assistance in their basic care needs, done by the certified nurses aides who had gone through basic requirements of going through nursing classes, and then they were licensed by the state of Hawaii. 2013 to 2014, I was a certified legal nurse consultant. As a legal nurse consultant, I assisted lawyers in any of their cases, discoveries. Because of my RN background, my expertise was best utilized in medical or health care related lawsuits to decipher and to interpret the medical semantics in a way that lawyers could understand the health issues of their clients so they could knowledgeably defend their clients. I could also be hired as an RN medical expert in court trials. 2015 to 2018, I was a licensed insurance agent with PFA, Premier Financial Alliance. In May 1970, my family immigrated to Hawaii. I was 8th grade at the time. There are about 184 dialects in the Philippines. I am quadlingual. Besides English, I could speak 3 different Filipino dialects, Tagalog, Ilocano, and Pangasinan, which are the 3 main dialects spoken by the majority of Filipinos both in and outside the country. Philippines is one of the few countries where Filipino children are automatically bilingual from the time they start school in kindergarten until college. Filipino school curriculum primarily taught in English, both reading and writing, due to the American influence that began in the early 1900s when William Howard Taft was commissioned by the U.S. government to establish an American civil government in the Philippines in 1902. In January 2013, I was faced with foreclosure issues. Both my home and my parents' apartment, which I was also paying their monthly mortgage, went into foreclosure. As I was one of the dozen CMA case management in the islands, I would know who the caregivers are anywhere in the islands, whether in person or I am familiar with their names. Mary Jean Castillo, Annabelle Cabebe, and Mila Castro I very much knew them personally as members of the foster care home arena, whereas Lauren Tropical, I only knew her by name. She was also a caregiver. It was Sergeant Castillo, hereinafter MJ, who introduced me to Anthony Williams' company called Mortgage Enterprises Incorporated. Right around the time she was hired as Anthony's employee, approximately May of 2013. I was one of Anthony's original clients dating back since May 2013 to this date. My initial personal experience with Anthony was one that he was honest, sincere, transparent, and he explained the process of helping us, as there were other clients besides me who were also in the same office during my initial meeting with him, requiring his assistance because they are all in foreclosure. He introduced himself to us in that meeting that he is a private attorney general and not a lawyer, and he is capable of assisting us or anyone else needing his services in their foreclosure issues. I was not familiar with this term, PAG, Private Attorney General, so I researched it later on. Since I was already in the foreclosure and court hearings has been initiated by my lenders, Anthony informed me that he did not guarantee that I would win my case, but perhaps he could detain them for as long as he could until I could get back up on my feet again. That was fair, and I accepted his rationale. About a couple of months after enrolling in his program, Anthony was taken into custody at OCCC, Oahu Correctional Community Center, and everyone in his circle of friends and clients were in shock. Ms. Castillo was one of the caregivers under my CMA. This was how we became close friends. MJ remained as Anthony's trusted employee, along with Sam T., who were the last two MEI employees. Since I no longer have a daily job, I was at her tail, so to speak, most of the time. The day after Anthony asked MJ to wire the money to Anthony's mom, Barbara, MJ showed me the receipt. MJ confided in me that she hired her own lawyer in the event that she might also be indicted because of her employment with Anthony's company. Per MJ, her lawyer instructed her to stay away from Anthony completely. MJ also has another trusted friend named Mel H., who was a captain in the National Guard at the time, doing his own pro se motions for his own foreclosures. MJ stated that she felt bad for, quote-unquote, abandoning the sinking ship. She further stated that I have to save my own self since I don't know how long Anthony will be in jail. I have bills to pay, unquote. But she remained in MEI to tie some loose ends, quote-unquote, for at least a couple of months before she left MEI completely. While Anthony was at OCCC, MJ informed me that she was visiting Anthony for at least 1 to 2 times a week to bring him papers that he needed and to obtain instructions from Anthony on what he needed to do to continue in keeping Anthony's office afloat and to continue to assist Anthony's clients until he is released. Anthony is an honest, sincere, and highly dignified man, morally and ethically, besides being a highly spiritual person. Before MJ left MEI, she asked her friends, Mel H., Sam T., and myself, if we could assist Anthony and his clients once she's gone. It did not take us a second thought of agreeing to take on this responsibility because as Anthony's friends, we respected, we honored, and we believed in his altruism. Our primary goal was to give Anthony's clients the options of what they could do to avoid imminent foreclosures since we did not know when he was going to be released. Our intent was to inform all the clients that were on the list, those who are willing to listen and those who are willing to work with us by, number one, tell the truth that Anthony was at OCCC, that we don't know when he's going to be released. And two, we could offer them an option to apply for home modifications with their respective lenders in hope to buy time for these clients from being foreclosed on, hoping that Anthony would be released at OCCC within a few months. Mel H. visited Anthony at OCCC at least once a week to obtain instructions from Anthony on what needed to be done to assist his clients and to update Anthony of what we have been doing for his clients. I know this as a fact because I was with Mel H. on every visit he had with Anthony. Only one visitor was allowed at OCCC. I stayed in Mel's van, no matter how long it took Mel to wait to get in to see Anthony. I usually waited in the hot parking lot at OCCC with the van's AC on. Mel H., Sam, and myself took on this job purely as, quote, volunteers, with no expectations of getting paid whatsoever. We believed in Anthony's altruism, so as his friends, we supported him. The three of us were not working anywhere at the time, so we had the time we needed to do what we needed to do to assist him. We met and worked at Mel's house as needed. Before MJ left MEI, she taught the three of us how to fill out the QWRs. Her rationale was that we could process these forms for Anthony, and once he is out of OCCC, he then could respond to the QWRs. It was MJ who added Mel H. and my name on the letterhead of Anthony's company just before she left MEI. MJ gave us a box full of papers from Anthony's office when she left. In this box, it contains some of the client's application forms, the list of clients' names, phone numbers, and their addresses, and a few MAI checks, rubber stamped in the back of the check that it was already deposited. Sam and Mel were not received well by the clients when they first started calling them on the phone. I was then volunteered by these two guys to do the follow-up phone calls instead because, one, I was trilingual. I could speak 3 Filipino dialects. Because I'm a female, perhaps the clients would respond better when a female voice on the phone. So Mel and Sam called the other clients on the list, and those that were willing to meet with them face-to-face, appointments were made. I don't remember exactly the total number of clients that were on the list, but I'm sure it was over 100 clients. We spent more than 2 months of Mel and Sam visiting clients' homes and me calling clients that were on the list. I did the follow-up phone calls on my own time at my house, calling mostly in the evenings and on weekends because this was when the clients were home and available to talk to. As expected, a lot of the clients were very upset. Mel Ace and Sam got the brunt of it. When the three of us meet at Mel's house, we shared our experiences doing all this follow-up. Mel and Sam stated that some of the Mel clients gotten so upset during their face-to-face meetings that some attempted to get physically and verbally abusive towards them. I remember some of the clients slamming the phone on my ears as well once they heard me say I'm calling on behalf of MEI. However, those clients who accepted us calmed down once they knew why we were reaching out to them and why I was calling out to them. In fact, most of the clients were thankful and felt relieved that Anthony and his company still had friends reaching out to them to inform them and to update them of what's going on with Anthony. The clients that I spoke to stated that they paid cash money to Henry Malinay mostly paid in the amount from $10,000 up to $15,000 in cash. The client stated that Henry promised them that he could help them with their foreclosures. The clients that I spoke to stated that they paid cash payments that were collected by Henry Malinay, Edna Franco, Annabel Cabebe, Rowena Valdez, and Angelina Pasion. These clients also stated that they were never given receipts, even if they asked for it, promising them that, quote, it will be given later, unquote, but it never happened. Most of the clients who give their payments to Henry and his cronies, meaning Edna, Annabelle, Rowena, and Angelina, these clients stated that they gave their life savings money to them with the hope that they would not lose their homes. Unfortunately, because these clients have no receipts to show for, they felt they had no recourse in proving what they paid, and they felt no authorities would listen to them if they reported it. As I continued to do my follow-up phone calls, I found out from the Maui clients that it was Henry and Rowena Valdez who used to go to Maui to give seminars in one of the hotel's meeting rooms. I asked one of the Maui clients to send me a copy of the flyer that Henry and Rowena was passing out for their free seminars. I saw with my own eyes a copy of the flyer that Henry and Rowena were passing out to recruit their Maui clients. These Maui clients that I have spoken to on the phone stated that Henry gave the seminar and Rowena collected the fees.
So I thank you. I really appreciate what you have to say. That with regard to Mr. Williams, though, if you want to give any testimony for sentencing.
Yes,
Because we've already gone through the trial, and the jury has come back with their decision, and I recall that you were given an opportunity to testify at trial.
Okay.
So if there's something that you personally would like to say about Mr. Williams,
Yes,
or his sentence, I welcome you to do that now.
Okay. When Anthony was extradited to Honolulu in September 2017, I was truly relieved because the lawyer that I paid retainer's fees to assist me with my foreclosure issues was a waste of my money. He did not do what he said he would do to assist me. I was still in foreclosure. It has been 8 years to date, from 2013 to 2020, that Anthony continues to assist me with my parents' foreclosure issues, even while he's incarcerated at FBC. Currently, Anthony is also assisting several other of my friends with the same foreclosure issues. Anthony is a victim of circumstance. He is the big fish that the government caught to keep lids shut as to make an example out of him. Every form of oppression, prejudice, and the violation of his human rights and his civil rights has been and continues to be perpetrated against him inside the BOP and in this courtroom in their hope of breaking him down physically, psychologically, and spiritually. However, Anthony is a realist, a truth seeker to the very core of his being. His love of Yahweh Elohim Yeshua, his dignity, his morality, his perseverance, his altruism, the genuine truth that he's standing firm for, these are what motivates him to show himself of who he truly is. I do not condone the actions of the far left, nor the far right, nor any actions done to harm humanity by the violent criminals, the mass murderers, the drug lords, the human traffickers, the pedophiles, or any others that commit horrific and atrocious harm to humanity. I even believe in capital punishment if beyond any reasonable doubt that one's guilty actions have been proven, and if it's this truly what it would take to eradicate such bad people as menace to society, especially if they're far removed from reality, have no remorse, and unrehabilitated individuals. The ring of greed and power that has been enslaving humanity, not only here in the United States, but worldwide, conceived and created millenniums ago by the dark elites of nobility, which continues to this day. The riots that are going on worldwide has upset and incited the general population mightily, globally, to arouse the consciousness of humanity against the asymmetrical economic warfare we are all faced with today, and continues to be astoundingly being perpetrated against humanity worldwide. In conclusion, Your Honor, Anthony's ex-employees, namely Henry, Edna, Annabelle, Rowena, and Angelina, are still at large. Although Henry and Annabelle were indicted with 1 count each, that is just the prosecutor's deceptive, egregious tactics to further add layers to their concocted lies and manipulations to ensure that their conviction of Anthony are merited. Anthony is not a felon, but rather he is victimized by these vindictive FBI investigator and prosecutors whose main intention is to prosecute and to persecute regardless of the truth, to make an example out of him, daring to push the limits, daring to penetrate the ring of power that they are protecting. Your Honor, you hold the balancing scale. You are the fulcrum of this teeter-totter of justice versus injustice. Anthony's future lies in your decision today. He is a man of dignity, and his main intention was to serve others. This was thwarted mainly because he trusted a group of people whom he thought holds the same core values and principles of his caliber. Anthony is a realist. He seeks for the truth, no matter what. And his uncompromising spiritual, moral, and ethical values that he exemplifies are what he lives by and executes to this day in his daily life. Anthony never would have thought that these kind of people have the heart to destroy lives, especially our Katunas, and think that they could get away with it. Personally, I am truly very ashamed, and I am truly very, very disappointed to be in the same culture as them. Anthony has been in this business for 19 years before coming to Hawaii in an attempt to help the local people. Except for another wrongful accusation in his Florida case, a double jeopardy that he is being tried for. His line of work has been spotless and legal in the eyes of law. American people and humanity worldwide are now, quote unquote, waking up to the truth, the injustices being perpetrated to those who were wrongfully accused and wrongfully prejudiced against. The division between, quote, us against them, black versus white, the powerful elites versus the innocent poor people, are now all surfacing in every major cities in America. Your Honor, you are given a very important job. Whether you believe in higher divinity or not, or you have your own religious beliefs, your unique woman qualities of having the special intuition of what is in your heart that resonates with the truth presented to you throughout this case. May it penetrate your heart and burn the iniquities and plant the truth of life instead. Perhaps today is just another working day for you, because this has been a job you have been doing since you were appointed by President Obama several years ago. Your Honor, you are a wife, a mother, a grandmother perhaps, a sister, an auntie. I'm sure that your passion when you were a little girl with service and fathers. And I assume that the reason why you closed this prominent, commendable job, a very respected position, is to serve justice. Your Honor, I'm asking you humbly, sincerely, in my heart of hearts, especially on behalf of Anthony's children, his family, and his friends, who could not be here in person today. We are asking for your mercy and grace to exonerate Anthony of all the wrongful accusations done against him. Being incarcerated for almost 4 years for a crime he did not commit is very bitter to swallow, yet he was made to endure. I believe in justice and equality. I still believe in our government. I still believe in our judicial system. And I still believe in the American dream. Your Honor, your children or your grandchildren might be one day follow your footsteps. The injustices being done against humanity and to Anthony has been assiduously horrific and atrocious throughout this case. Your Honor, you have the power to change these injustices, to do what is righteous, to not destroy a dignified man's life. As Americans, we need and we must move forward as a united people to once again become a country filled with love, peace, unity among each other. Your Honor, you have the power to dissolve the ring of greed and power that is rampant in this day and age. May your heart be filled with love. Thank you very much.
Your Honor, I understand that there are two other individuals who paid money to Anthony Williams who wish to speak. I do understand that at least one of them, if not both of them, were on the defendant's witness list, so an instruction may be appropriate to ensure that the communications are limited to the sentencing proceeding and not to the underlying facts.
Who's the first and the next? All right, so good afternoon, welcome. Please speak into the microphone if you could state your name. And then I would just remind you that this has to be about Mr. Williams and not the underlying case, because the trial's already been held and the jury made its decision. And I'm compelled by law to uphold the jury's decision. Of course, Mr. Williams has the right to appeal his conviction to a higher court. Okay. Good afternoon.
Thank you. Good afternoon, Your Honor. Good afternoon, officers of the court. Thank you for this opportunity to let me speak. I apologize. I'm a little overwhelmed, emotional. My name is Elavila Giles. I'm 73 years old, retired. I'm a mother of 3, a grandmother of 7 young boys, and a woman of faith, of great values, deep values. I'm a Christian, as I understand Anthony's faith. I met Anthony Williams in the home of Henry Maloney in 2013. At that time, my home was going through foreclosure, and Henry was a very good friend. We had been in multiple businesses together, and he called me and said, maybe we have help for you, so come on over. So I did. I went over there and met Anthony, very nice person, and the program was explained to me, and I thought it sounded really good, and I paid my $500 by check. I'm sorry, I can't even see my notes because of my tears.
Would you like some Kleenex?
Okay, thank you. I forgot my glasses too. Okay, thank you. I also witnessed many other people, including Henry Maloney, whose home was also being foreclosed on, going through the same process with the intent of keeping our homes, not, avoiding foreclosure. And I thought that was a great thing for Anthony to do, and I was very supportive of it. And I did, although I had other friends who were also going through foreclosure, they didn't participate in the program. When Anthony was incarcerated, I couldn't continue the process, so I then had to work with Edna Franco, and of course, she was a lot more costly in terms of money. She wouldn't do anything for me unless I paid up front the amount of $1,500 or $2,500. And of course, that set me back quite a bit. So I was like, okay, in order for me to get out of foreclosure, I got to pay you more money. The bank, that money could go to my bank. But in any case, she eventually disappeared and left me where I was. Not any better, but probably a little bit more worse, because now I had paid her money instead of putting it into my mortgage. My experience with Anthony has always been that he's a very kind, compassionate, and was very, very helpful. When he came out of, I think, during one of his incarcerations, I was able to get some more help from him, and I was able to go and file my own paperwork with his direction until he was incarcerated again. So then I was lost again. But I always found him to be very helpful. There was never any intent to harm me or anyone else that I knew that was working with him. He came across as a very humble person who was just there to help people to prevent foreclosure and to be able to stay in their homes. And I saw a lot of people being helped by this man. And above all, he educated them. He educated us and not to get frantic, not to lose our hope, but that there are things that we could do in order to overcome the foreclosure or get out of foreclosure. So I find him being charged and being incarcerated heartbreaking, totally heartbreaking, because I only saw him help a lot of people, including Henry and all those other people that got the check. I even witnessed that they got the check and they spent the check. This man did not spend those checks. I saw the many checks that they cashed. In fact, they even bragged about it. They even took a trip to the Philippines and had so much money they were throwing it out. And that broke my heart, because to have an honest man like Anthony being, I don't want to say the word framed, but that's what it seems to me. I don't know any legal terms and so forth. But it seems like he has been framed, and I am heartbroken because I only saw him help people to stop them from being foreclosed upon. And I'm here today to plead with you as the person overlooking this case, that it would be criminal to punish this man any longer, because I know his heart is to help people. I know he's not there to rip people off. I know he's not there to put people out of their homes. On the contrary, he he is there to help them stay in their homes. He takes his time. He doesn't pay. I mean, he didn't pay me for the hours of work that he put into. I didn't pay him. I paid Edna, who didn't do me any good, but Anthony did not charge me to help me, and I am still in my home today because this man helped me. So I'm here to just plead for him, for mercy, for whatever it's called, because I think this man has a good heart, and I don't think he's harmed any of the people. I suspect that the people that were harmed by the people around him who took the money and spent it rather than conduct the business of saving people from foreclosure. And that's all I have to say. Thank you for the opportunity to speak today.
All right, thank you very much.
Thank you for listening.
I'm notified that the third witness would not like to speak.
All right, thank you. Is there anyone else in the courtroom? Opportunity? I just want to make sure we're not overlooking anyone. All right, let the record reflect there's no response. All right, so then the court's going to state the sentence and the reasons for the state of the sentence. And then with the special conditions, and then I'll ask the parties if there are any legal objections to the sentence before I impose it. So as the court had previously determined, the applicable guidelines are total offense level 41, criminal history category 5. The guideline range is 360 to 7,680 months. The court does grant the defendant's motion for a variance, and I am going to make the sentence you're committed to the custody of the Bureau of Prisons for a term of 240 months as to each of counts 1 through 32. To run concurrently, and all for a total of 240 months, and all to run consecutively with Florida case number 17-000074CF103.
20 years!
As I had the discussion with Mr. Yates, the court recognizes that under the United States Sentencing Guidelines, Section 5G 1.3G, the sentence for Mr. Williams' case for the 32 counts may be imposed to run concurrently, partially concurrently, or consecutively to any prior undischarged term of imprisonment to achieve reasonable punishment for the intent offenses. Why I do believe that Mr. Yates has a good argument with regard to concurrent to the Florida case. I was persuaded by Ms. Thomas's testimony today, or her statement, that Mr. Williams continues to apparently advise people on the same thing that he got convicted in this case for, and that he got convicted similarly in Florida. And therefore, I think it is a continuing behavior, and that needs to be reflected in the consecutive sentence. So that's my reason with regard to that. Supervised release of 3 years for each of the counts 1 through 32 to run concurrently. No fine, making a specific finding that based on your financial obligations, particularly
Hi, the person you're about to speak with has closed captions turned on. They'll see captions of what you say to help them listen along.
$30,527.13. Special assessment of $100 for each count for a total of $3,200. The terms of your supervised release. You must abide by the mandatory and standard conditions of supervision, including the following conditions. The court waives the mandatory drug test condition because you do not have a recent history of substance abuse and the offense is not drug related. You must cooperate in the collection of DNA as directed by probation. You must report to the probation office in the Federal Judicial District where you are authorized to reside within 72 hours of the time release, unless the probation officer instructs you to report to a different probation office or within a different time frame. You must abide by the following special conditions. You must participate in a mental health assessment and any recommended treatment in a mental health program and follow the rules and regulations of that program. The probation officer, in consultation with the treatment provider, will supervise your participation in the program, such as provider, location, modality, duration, and intensity. Restitution of $230,527.13 is due as specified in PSR Attachment A. Any unpaid balance is to be paid during the period of supervision in monthly installments of 10% of your gross monthly income, commencing 30 days after the start of supervision. The court may order this requirement to be changed from time to time as circumstances warrant, but no court order shall be required for your voluntary agreement to pay more than the court-ordered amount. Interest is waived. Payments must be made on a payroll deduction when applicable. You must notify the probation officer of any change in financial circumstances that affect your ability to pay. Your financial circumstances must be reviewed by the probation officer on at least an annual basis. The victim's recovery is limited to the amount of their loss, and the defendant's liability for restitution ceases if and when the victims receive full restitution. You must provide the probation officer access to any requested financial information and authorize release of any financial information. The probation office may share financial information with the attorney's office. You must apply all monies received from tax, income tax refunds, lottery winnings, inheritance, judgments, and any anticipated or unexpected financial gain to the outstanding court-ordered financial obligation at the discretion and direction of the court. You must not incur any new credit charges or open additional lines of credit or apply for any loans without prior approval of probation. You must not borrow money or take personal loans from any individual without the prior approval of the probation officer. You must maintain a single personal bank account, separate and apart from your spouse and your family members or others, into which all income, financial proceeds, and gains must be deposited and from which expenses must be paid. You must provide the probation officer with a signed release authorizing credit checks and an accurate financial statement with supporting documentation as to all your sources and amounts of income, all your expenses, and any business you own in whole or part. You must provide the probation officer with access to any and all business records, financial records, client lists, and other records pertaining to the operation of any business you own in whole or in part as directed by probation. You must not be employed in any position that requires licensing or certification by any local, state, or federal agency without the prior approval of the probation officer. You are specifically prohibited from practicing law without prior approval of the probation officer. You must not represent yourself as a private attorney general, a lawyer, an attorney, a government employee, or law enforcement officer. You must disassociate yourself from the Common Law Office of America, Mortgage Enterprise Investment, and Mortgage Enterprise. You do not have any contact with any principals, associates, and or employees of these businesses. Should any of your family members work for these businesses, you must reside at a residence separate and apart from those family members. You must submit your person, property, house, residence, vehicle, papers, or office to a search conducted by a United States probation officer. Failure to submit to a search may be grounds for revocation of release. You must warn any other occupants of the premises may be subject to searches pursuant to this condition. The probation officer may conduct a search under this condition only when reasonable suspicion exists that you have violated a condition of supervision and that the areas to be searched contain evidence of this violation. Any search must be conducted at a reasonable time and in a reasonable manner. So the reasons for the court sentence are stated in its aggravating and mitigating circumstances. The court certainly considered a total sentence of 360 months, but really focused on whether it should be consecutive or concurrent, and landing on the side that it's appropriate for just punishment for it to be consecutive because of the similarities and the consistency of them, even today apparently continuing in the behavior. Further, to the extent that Mr. Williams has raised challenges to the amount of the loss and so forth, the court notes for the record that its sentence is actually below the guideline range, and therefore even if he is correct, which I don't believe he is in terms of the calculation of his guidelines, it's clearly a sentence that reasonably reflects both loss and his culpability. It's a significant sentence, but if for some reason the calculations were incorrect with regard to that, it's still well within, I think, the veil of reason is reasonable. Before I impose the sentence as stated, Mr. Yates, any legal objections from the government?
No legal objection from the government, Your Honor.
All right, thank you. Mr. Williams, any legal objections before I impose the sentence?
Yes, I'm having Mr. Isaacson chime in with the legal objections.
Mr. Isaacson, do you have any legal objections that you want to state?
Your Honor, in terms of the legal objection to the sentence, I believe it's under the statute, it is within your ability to impose the sentence. Yeah.
Thank you. All right, the court has considered the advisory guideline computation of the sentencing factors under 18 U.S.C. Section 4553A. As I explained more fully in my assessment of the specific aggravating and mitigating factors found in this case, I have considered Mr. Williams' history and characteristics, as well as the serious harm to our community caused by his offenses, and the particular seriousness and gravity of those offenses for those vulnerable in our community.
But you did not consider that, though.
So I have listened my turn to speak, Mr. Williams, and then I'm going to be asking you some questions as to if you want me to make any recommendations for the Bureau of Prisons. I have read the letters received on behalf of Mr. Williams. I have taken in testimony with two of his witnesses here at the sentencing hearing. I believe his sentence provides just punishment and equally important, I hope it serves as adequate deterrence to others. I have considered the sentencing guidelines and the policy statements and the law. All right, so Mr. Williams, do you want the court to make any recommendations as to placement by the Bureau of Prisons?
Yes, to send me home because I didn't commit a crime. They couldn't get not one person that they said was a victim to come and speak at this hearing because they know they were lying.
I'm sorry, excuse me, Ms. Lloyd. So you want me to recommend to Bureau of Prisons placement in Texas, in that area, or when you say send you home? Is it a geographic location?
Atlanta.
Atlanta. All right, because of family relations in that area. Is that correct?
That's correct, but I won't be able to do any prison time because I'm gonna get this returned before my Florida anyway.
Right. So, you'll be serving it after your Florida term of imprisonment. But I will make the recommendation of designation to the Atlanta area because you have family relations with regard to that. So you were convicted after a jury trial, Mr. Williams. You do have the right to appeal your sentence as well as your conviction and the manner in which your sentence was determined. However, there is a deadline for your notice of appeal to be filed, and it has to be filed within 14 days of the judgment of your criminal case, your conviction, and sentence. If you file later than those 14 days, you could be determined to be too late and to waive or given up your right to appeal. Do you understand?
I understand and comprehend.
Thank you very much. Anything further, Mr. Yates, at this time?
Nothing from the government, Your Honor.
And Mr. Isaacson, is there anything that you need to place on the record? All right. Then I thank everyone, and we are.
I want to place this on the record.
Well,
I need to
we're
place
actually
it on
done.
the record.
We're actually done with the sentencing hearing now, Mr. Williams. So good luck to you on your appeal.
And I just want to place on the record that all of you are going to pay for this. You're going to go to jail for this because this is not going to be. I'm not going to let you violate my rights like this because it's going to. You all going to. Hello? Hello?
It's all better than up. Better up.